If you want to go ahead and move to the next slide, that would be great. Sure. There you go. Wonderful. All right, so welcome everyone. So glad to have you here. So glad for your interest in Right to Counsel. I'm going to go through a lot of information very fast today in the hour that we have. I'm going to try to stop a few minutes early so that we can have time for questions. But the most important thing, one of the most important things you'll get out of this is the URL that you see on the slide right now, civilrighttocounsel.org, which has a lot of the information I'm going to talk about. My coalition has about 300 participants and 200 partners in 40 states, including many in Maryland. And our work is to, as it says, we support litigation, legislative efforts, and research around the right to counsel and basic human needs cases, such as housing, domestic violence, child custody, public benefits, immigration, truancy, mental health, and others. We do a lot of work to raise public awareness in the media and elsewhere, and we serve as an information clearinghouse, especially through our website, which you'll be seeing throughout this presentation. Next slide. So the important thing to know is that when we talk about this movement, we don't use the term civil Gideon anymore, and the reason is that Gideon v. Wainwright established a broad, across-the-board federal right to counsel all at once for criminal defendants. As I mentioned, we focus on basic human needs cases, not all civil cases. We also are state and locally driven. We're not looking for a federally established right to counsel, and we are incremental. We work one issue at a time, one state at a time, sometimes one city at a time. That's the nature of this movement. It's very different than Gideon. Next slide. Many of you, or most of you, I imagine, already would know most of this information, but it bears repeating what some of the benefits of right to counsel are, and they're going to become especially clear as we start to talk about what's happening in the COVID-19 era. But as we discussed, we're focused on only the most critical kinds of civil proceedings, the ones where people's most fundamental needs are at stake. We have significant evidence that you're going to see later that full representation, as opposed to other kinds of legal assistance, dramatically changes the outcome in civil cases. A lot of these civil proceedings, especially if you look at things like housing, involve typically the other side is always represented, whereas the tenant is not. So that providing counsel helps restore equity in the proceedings. There are significant financial benefits in providing counsel, which we're going to talk about as well. It can diminish the impact on an already strained indigent defense system because civil proceedings that are not tended to can actually spiral out of control into become criminal proceedings, like when child support turns into a criminal matter, when people who are evicted are homeless and then are arrested. There are many examples of the intertwining of the two systems. And we're also going to talk about the disproportionate impact on communities of color, which especially during COVID-19, which itself has a disparate impact on communities of color, doubly worsens the problem. Next slide, please. So we're going to talk about, briefly first, what everything looked like before COVID-19 hit. Next slide, please. So basically in criminal cases, the right to counsel has been over many years, many decades, was basically expanded from almost nothing to covering even misdemeanor cases. Next slide. Unfortunately, the Supreme Court's view of civil cases has been quite different, where after recognizing a right to counsel for juvenile delinquency cases, which are technically civil, it's rejected the right to counsel over and over as a federal constitutional matter, including most significantly for termination of parental rights and for a person who went to jail for over a year for failing to pay child support in a civil proceeding. Next slide. Fortunately, the states have actually acted quite extensively in the absence of the U.S. Supreme Court's rulings affirming such a right. And the areas you see on the screen right now, a lot of them dealing with family law or mental health, a lot of them, the states have, to a large degree, acted to provide a right to counsel either by statute, by constitutional decision, often under the state constitutions, which can be broader, interpreted more broadly than the federal one. And as you can see here, Maryland has done quite a bit in a lot of these areas. Next slide. Then there are some areas where we have like about half the states, but not a majority, that provide a right to counsel. Again, it's a lot of proceedings involving family or mental health, things like paternity, adoption, confinement of sexually dangerous persons, adult protective proceedings for adults who are a danger to themselves. We're doing pretty well in the sense of having about half the states recognize a right either statutorily or constitutionally. Next slide. Then we're dealing with some areas, extremely important ones like private child custody proceedings, domestic violence, where only a few states guarantee a right to counsel. Next slide. And then there are some areas where no state, although some cities provide a right to counsel, such as housing and health outside of, for instance, health proceedings to contest like the loss of health care. There is no state that provides a right to counsel for that. Next slide. If you wanted to see all of this, we actually have on our map, you can actually see you can pick a subject area. You can't really tell on this slide, but underneath the pop-up box that's there, there's a selector where you can pick a subject area. It will then, like in this case, it's looking at adoption for birth parents, whether they have a right to counsel. There's a key that shows you the colors, which shows you it's quite a complex picture in terms of the right to counsel. And then if you clicked on a particular state, you get a pop-up like this that would explain the status of the right to counsel. So you can do that for Maryland. You can also just say, I want to see everything for Maryland, and it will show you that as well. Next slide. So where did this leave us prior to COVID-19? 3/4 of all civil cases involve at least one unrepresented party. In housing cases, we typically see about 90% at least of the tenants are unrepresented, whereas about 90% of the landlords are represented. About 80% of the civil legal needs of the poor go unmet, and this really startling statistic in Virginia where when it was looked at across the board for civil cases where only the plaintiff was represented, the plaintiff succeeded 60% of the time, and when both sides had counsel, that rate dropped to 20%, showing just dramatically how much difference counsel makes, especially where one side is represented and the other side is not. Next slide. So I also just want to take a moment to say that we're also seeing a significant rise in civil incarceration. I mentioned the Supreme Court's decision earlier about child support. A lot of people are also locked up for inability to pay court fees and fines that are imposed in a criminal proceeding. Those collection proceedings are not criminal typically, they're civil, and a lot of people are jailed because they can't pay those and are unable to prove that they can't pay those without a lawyer. These statistics from the Survey of Inmates in Local Jails show some of the numbers of people who are jailed for non-criminal proceedings. And you'll see public order circled there a lot. That has to, the public order is what covers like child support. And these numbers, which are in 2002, are dramatic undercount of what you would see now, 20 years later, where pretrial incarceration for fees and fines is through the roof. And they were not really looking at that time. Next slide. It's really worth talking again, especially in the wake of the racial impacts of COVID-19, to look at who's been disproportionately impacted by the lack of counsel, like who is going to court without counsel. Next slide. So these statistics we're looking at nationwide eviction statistics and found that Black female renters were filed out for eviction at double the rate of white renters or higher in 17 of the 36 states that they measured. So Black female renters are far more often in court, and therefore, because almost no tenants have counsel, they're far more disproportionately impacted by the lack of a right to counsel. Next slide. In Baltimore, these statistics from Rent Court looked at found that 93.7% of the people in housing court were Black women, and that's this was a representative sample. So basically, again, seeing really dramatic numbers in Baltimore. Next slide. These statistics that you'll see next are actually from a study that was just completed in Baltimore that looked at racial demographic statistics in housing court. I'm actually not seeing the slide advance. I don't know, Jane. There we go. Okay. So basically, this slide shows that basically Black women are evicted at about 4 times the rate that white men are in Baltimore. This was a study just released by Tim Thomas, and shows also where evictions are concentrated in Baltimore. Next slide. These statistics from Chicago look at the eviction filing rate, so who's subjected to an eviction filing, and found that Black tenants were subjected at an eviction rate, a filing rate significantly at a significantly higher rate than whites, and is significantly higher than just the overall city average. And it found that 16 of the 19 community areas with filing rates over 50% were majority black areas. So basically, all across the city, the areas with the highest concentrations of black tenants were also faced the highest rates of eviction. Next slide. Philly, again, similar numbers, looking at in areas where the population is less than 10% black, the eviction rate was only 3.1%, but where it was greater than 80%, the eviction rate was 3 times higher. So that's really startling statistics. Next slide, please. And again, more statistics, really just to show the point, this is really the same everywhere, seeing rates 3 to 5 times higher, not just for, and also not just for black tenants, but for Hispanic renters as well, seeing really high rates of displacement and eviction filing for people of color. So when we talk about the lack of right to counsel, it affects all poor people, but it especially affects people of color even more because of how often they're in court, especially in housing court. Next slide. Okay, so what were we doing to try to address this before COVID happened? Next slide. This is really, I'm not going to take the time to go through all this except to show you the breadth of what was happening legislatively on right to counsel. The important thing here to recognize is that there was right to counsel legislation passed. You can see the asterisks indicate places where legislation passed. So a lot of legislation passed last year and this year, even before COVID-19. And the interesting thing is the breadth of the areas. So you see family law, domestic violence, guardianship, civil forfeiture, immigration, lots of activity in a lot of different areas. And also the states that are pushing this are not the typical states you'd expect. You've got North Dakota, New Mexico, West Virginia, Arkansas, Missouri. We're looking at a wide breadth of the movement. Actually, Missouri is the one negative bill up there, so I should not give that as an example. But all of the other ones are positive bills. And again, we're seeing this movement really across the country. Next slide. This was one bill in particular that we worked really hard on, which actually was addressing, we actually pretty much wrote this bill, which is about appointment of counsel in federal court, where a lot of civil litigants bring civil rights claims, especially prisoners, and are not appointed counsel, and this bill would increase the rate of appointment of counsel in the federal courts. So getting Congress in the act too was a new part of the work, and we'll talk more about that in the housing sphere in just a moment. Next slide. So although I showed you the breadth of a lot of the bills, the housing is really taken off in the last 5 years, and we're going to talk about that for a bit. Next slide. So basically, one thing that's really changed is like right to counsel, which really was a hard issue to bring to light before, has really taken the mainstream media's attention and the mainstream public's attention and lawmakers' attention. It's become a hot issue. It's become a central issue to looking at the housing crisis and the homelessness crisis. So this is U.S. News. Next slide. And this is from the Wall Street Journal, looking at, and there's really a really systemic look from the Wall Street Journal at looking how the movement to provide a right to counsel was happening all over the country, as you're going to see in a moment. Next slide. And this is from Next City. One of my favorite headlines of the year is Tenant Right to Counsel on its way to becoming standard practice. Next slide. And then the Washington Post opinion piece, why have a right to counsel in criminal cases? Why not evictions? Why not indeed? Next slide, please. So these were places that have already passed a right to counsel for tenants facing eviction. New York City, San Francisco, Newark, Cleveland, and Philly. The coverage of what they cover is different in each city. They have different limits. The San Francisco one was actually done by ballot initiative, not by legislation of the city council. We're going to see some of the stats from the only 2 cities we actually have data from so far, New York and San Fran, and I'll share some of that data with you. But 5 cities in 3 years, given that we had no right to counsel anywhere in housing court prior to 2017, is pretty miraculous. And New York City being the first city with it has over 200,000 eviction filings every single year. So a city of that size providing a right to counsel for all low-income tenants was a really incredible thing and really helped break the ice for the movement nationwide. Next slide. These were all places that were looking to advance the right to counsel even right before COVID hit. These were places where legislation was pending already, and in some cases really moving forward fast, especially Los Angeles and Massachusetts, really seeing a lot of like broad support, a huge statewide coalition in New York, in Massachusetts, and so on. Next slide. And these are all places where legislation hadn't yet been filed, but we've been working with advocates or policymakers in all of these places. And again, you look at some of these places, whether it's Toledo, Ohio, or Charleston, South Carolina, or these are not Kansas City. These are not the first places you might think of as far as the housing right to counsel movement happening, and just going to show just how quickly things are moving and how widespread the movement was prior to COVID-19. Next slide. And just to mention, that was not a complete list of everywhere that's working on it. That was just a highlight of some of the places working on it. We also worked hard with Congress. Increasingly, members of Congress were contacting us saying, we want to work on this issue. We want to deal with tenant rep. What's the best way to do that? We convinced a number of members of Congress that the way to do that was actually provide funding for cities and states that provide a right to counsel for tenants, to basically condition funding on passage of a right so that it would trigger not simply just increased representation, but an actual right. These 4 bills were all filed in 2020. They are obviously not yet, they didn't move yet, but in light of the huge crisis that's facing the courts, we're really glad that these bills are in place, and are looking forward to working with members of Congress and trying to figure out how to get eviction right to counsel funding into one of the relief bills. Next slide. It's also worth mentioning that the presidential candidates all of last year, starting with Cory Booker, explicitly included federal funding of city and state right to counsel as part of his housing platform, and then that was copied by pretty much all of the major candidates except for Biden over the course of the year. Next slide. It's also one of the really significant things that changed the nature of the movement is for a long time the right to counsel movement was driven really by attorneys, and what we saw with housing was the victories in New York and San Francisco and Newark especially were really driven by and caused by the organizing, the tenant organizers in those cities. They organized thousands of people to write cards and send letters and show up at protests and push the mayor, push the city council, demand that these be done as a matter of tenant power. And that's such a change for the movement, and we're really looking to trying to learn from that and trying to make client-centered sort of advocacy part of all of the right to counsel efforts that we're engaged in to the degree we can. But seeing like a room full of people chanting right to counsel is not something that has been historically part of the movement. So that's a really significant change. Next slide. As I mentioned, we do litigation as well. As with legislation, you'll see that there's a wide breadth of areas where we are involved in litigation. Family law is a big one again, child custody, child guardianship, some health cases, some ones about debtor's prison, which is people being incarcerated for not being able to pay money, adult guardianships. We did a significant case in New Jersey about suspension of driver's licenses for inability to pay child support. You can see that the ones with 2 stars are cases that we've won over the last several years, and some of those were groundbreaking. The driver's license case, which the trial court ruled that the state could not suspend driver's licenses without first holding a hearing and providing counsel, and the child guardianship case where the Massachusetts Supreme Court held that a private child guardianship case, the parents were entitled to appointed counsel. Those were first of their kind rulings, which we are really excited about. And again, the breadth of states where the litigation's happening, you've got Nevada and Pennsylvania and Indiana and Ohio, in addition to Massachusetts and New Jersey and other places. The Maryland case actually is about a person subjected to guardianship who felt that the guardianship had been imposed, and she several years had passed, and she was no longer had the incapacity issue that originally justified the guardianship. She tried to file herself to terminate it. The court denied it. She sought appointed counsel. The court denied appointed counsel. Her appointed counsel, her counsel tried to file a motion to challenge the guardianship. The court wouldn't even hear it. We took it to the Court of Special Appeals. We helped Disability Rights Maryland. Sorry, I should say. Disability Rights Maryland brought the case to the Court of Special Appeals, and we helped them with that. And the court just sent the case back down to the trial court for further clarification of what actually happened, because the factual record was kind of a mess. So the case is still going. Next slide, please. Another big part of the work is looking at and making the case for how effective full representation is. This was a meta-study done by Rebecca Sandifer, who won a Genius Award for her work on access to justice research, and she looked at how much more, based on all the aggregate prior studies, how much more likely were people to win when represented by counsel versus themselves, and she found that even in cases that were below average procedural complexity, people were 14 times more likely to win if they were represented by counsel. Next slide. I want to share a little bit of the data that's come out of New York and San Francisco, because again, that really helps support the right to has helped support the right to counsel efforts that we've been engaged in other states. Next slide. And you can see evictions have been down. These numbers are really startling. These are from New York City, where the City Office of Civil Justice has been issuing reports every year. 84% of tenants are staying in their homes. The evictions are down 41% overall, including 15% just in 2019 alone. Eviction filings are down by 30%, which does not surprise us, because a lot of filings are frivolous by landlords who know that they can't evict someone, but they're doing it anyway because the tenant doesn't know better. Default judgments, which means tenants not showing up for court, are down by 34%. Next slide, please. And then in San Francisco, which is the other place that we have, oh, sorry, one more thing about New York. The judges in New York, the housing court judges, actually testified in hearings that actually having counsel not only has it not slowed down the housing courts from their perspective, but it's actually increased court efficiency, made the proceedings more fair. So they've actually been hugely supportive, which has not always necessarily been true of housing court judges nationwide. And having that testimony has been hugely helpful in trying to get additional court support. Next slide, please. So San Francisco, similarly, a filing rate has gone down. 67% of people are staying in their homes. San Francisco's right to counsel has no income limit, unlike all the other ones that have passed. And despite that fact, we see that the people who are availing themselves of it are the people we would want to be availing themselves of it, which are people who are extremely low and low income for almost the entirety of it. Next slide, please. This is a little bit of data from Massachusetts, which looked at, this was a pilot project done in about 5 years ago in the district court, which was the primary study. They found that, and this study was interesting because it did not compare people who got full representation to people who went by themselves. It actually compared people with full representation to those who got lawyer for the day assistance. So they were given, the lawyer for the day tenants were given substantial advice, guidance, potentially help filling out forms to bring to the court related to their eviction proceeding. And yet, despite that substantial assistance in the district court, the represented group, the fully represented group, did twice as well as staying in terms of staying in their homes, saved 4 times as much in rent, and paid nothing to their landlords on average, compared to over $600 for the group that got limited assistance. So this, the studies that have come out thus far about limited scope have not been super encouraging. We're still, open-minded to those, to seeing evidence that limited scope can provide the same kind of results that full scope can. But the data so far has not been hugely promising on that front. Next slide, please. Just to not overemphasize housing, some of the other effectiveness studies that have been done, this is just a smattering of, there have been many, many studies done that look at what happens when you give people counsel and domestic violence, the rate of getting protective orders and immigration, avoiding removal and public benefits, getting making a successful claim. There are lots and lots of these studies. We have them all on our website. I'll show you where later where you can find these. Next slide, please. Also, in addition to looking at the impact on outcomes, we also look at the impact of costs, like what costs can cities and states avoid if they provide counsel. Lots of these studies are happening, have happened, and they are extremely important in looking at, for instance, like in the housing context, avoiding homeless shelter use, avoiding prisons and jail use, avoiding emergency health care, same for domestic violence, avoiding emergency police services, the healthcare costs, and so on. In a lot of these contexts, there are significant costs that are paid, and we've always made the argument that it's better to invest the money upstream with counsel than to pay for it downstream with all these emergency expensive services that are really, closing the barn door after the horse has already escaped. What's interesting too is that the funding for these pilots have come from a lot of different sources. They've come from federal, state and federal funding, but also from private foundations. And so just getting people to think creatively about where they might be able to get some of this funding from is really important. Next slide. These are just a few of the examples of cost-saving studies. The New York City and Philadelphia ones looked at eviction specifically. New York City's report, which came out right before the city passed a right to counsel, found that the city would save net $320 million a year if it provided a right to counsel for tenants. Philly's report found that it would save $45 million if it spent only $3.5 million. Philly now has a right to counsel, as you saw. These reports were extremely important in getting to the finish line with respect to that legislation. And then some of the studies in other contexts, like disability benefits, that every dollar spent on getting on disability benefits, legal assistance, resulted in $15 in new money into the state, and medical legal partnerships where hospitals help people apply for health care. For every dollar the hospital spent on legal aid, they brought in $16 in new hospitals billings revenue, which is incredible rate of return for them. Next slide. Also, really, I think important is that the right to, you saw the sort of media awareness of the right to counsel, that when it tested, the right to counsel as a concept does really well in the public eye. That basically Voices for Civil Justice, which did intense focus group studying on messaging about legal services, found that right to counsel was actually one of the most favorable messages across the spectrum of people they surveyed in terms of being supported, just universally, even no matter how it's phrased. But especially, you can see at the top, ensuring that every person has a right to a lawyer, that there was strong favoring of that. 88% favored that. Next slide, please. Similarly, the Vera Institute just did a survey recently about immigration and found that 87% support publicly funded attorneys in immigration court, which, again, it's not surprising, but it's really good to have the data showing that this is publicly popular and not just something that's being pressed for by advocates. Next slide. So we are halfway through the presentation, and we are now at the point where we're going to talk about that was then. And I think the important thing to emphasize before we talk about COVID is that this was a movement that was really surging. You saw it had a wide breadth of reach in terms of the which cities and states were working on this, what subject areas were being worked on. There were tremendous legislative victories. There were tremendous litigation victories. There's all this incredible social science research, public opinion research, and then we head into COVID-19. So where are we now? Next slide. So basically, as the title suggests, what we have now, and this is not going to be a surprise to anyone on this call, is a massive spike of demand in certain civil legal areas. And one of the three that were highlighted in this LA Times article were domestic violence, eviction, and healthcare. Not any surprise. Yet, as the article points out, the CARES Act only had $50 million total out of a $3 trillion bill for legal assistance, which is basically almost nothing when divided up among the 50 states. The budget of the Legal Services Corporation in an ordinary year is about $450 to $500 million, and that only reaches about 20% of the need, and that's before a pandemic. So we're dealing with a massive spike without the infrastructure in place, without the funding coming down from Congress to help provide, additional support. Next slide. One of the really big problems we're dealing with right now is that we have Congress and the states have acted to try to stop evictions, but yet the law is being routinely ignored in a lot of the states, which is one of the reasons why people might think, why do we need counsel? And if there are eviction moratoria, this is why, because the moratoria are being ignored in a lot of places and the courts are not catching that. This was from Time looking at eviction moratoria being violated across the country. Next slide. Landlords shutting off utilities, locking out tenants. This is all stuff that's happening all over the country despite the moratoria, and showing why the lack of a right to counsel is so damning, because if we already had a right to counsel, they'd be able to those attorneys would be able to jump in and deal with these, but almost all of these tenants are represented in all of these places. Next slide. The Federal CARES Act, as you probably know, halts evictions for publicly subsidized tenants or tenants who are living in publicly subsidized housing that is federally backed, like HUD-backed mortgages. But landlords are routinely violating the ban. We're going to talk about why that's happening, but basically it's not just the state bans that are getting violated, it's the federal one, which covers maybe about a quarter of the renters in America, is being violated constantly. Next slide. So this is some of what is more complicated during the COVID-19 era. So the CARES Act, which I just mentioned, it's almost impossible. It basically is practically impossible for a tenant to know if they live in a property covered by the CARES Act. They will know if they are a Section 8 tenant, but if the property has a HUD-backed mortgage, they're certainly not going to know that. That's something that you have to try to use one of the lookup tools that's been created to use, which they're not going to know about. And the lookup tools are often inaccurate, and they don't cover the smallest properties, the 1 to 4 unit properties. A number of states, as you can see on here, have required landlords to certify that their property is covered by the CARES Act, but in the states that don't have that certification, the landlords are just filing these evictions. They're not saying whether they're covered or not. The courts are not challenging them. The courts would also not have any way of knowing. And even where these certifications are required, they're not always being done. The law on moratoria is incredibly complicated. There's the CARES Act moratoria, there are state-level moratoria, there are city-level moratoria. Some of them are issued by the governor, some of them are issued by the courts. Sometimes it's both. The pieces of the different ones may overlap to some degree or not overlap. They have different expiring dates. As noted here, some of the moratoria say that a landlord can't even file an eviction. Some of them say they can file, but the court can't hear it. Some of them say the court can hear it, but the sheriff can't execute it. Expecting that the tenant's going to know what rights they have through all this is basically impossible, given how quickly everything is moving. And some of the moratoria require tenants to demonstrate that the only way they get protection from an eviction is if they can prove that they had a COVID-19 financial loss, which is a very difficult thing to prove in many circumstances. It's not so simple always as just the person's lost their job. They may have had reduced hours. They may have had a second wage earner lose their work. They may have child care costs that were new. Trying to demonstrate that all to the sufficiency of the court is actually a mini trial all of in itself that they need counsel for. Next slide. Sorry, I'm not seeing the slide advance yet.
It should say an avalanche of eviction.
There, okay, yeah, there it is. Okay, yeah. So now we are, so that's all of what's going on during the moratoria. Then we have what's going to happen after the moratoria expire, which is actually starting to happen right now. Some of them have already expired. Some of them end at the end of May or at the start of June. And we know that what's going to happen is there have already been a ton of evictions filed. Most states didn't prevent landlords from filing. We're going to have hundreds of thousands of tenants, if not millions, that actually don't have the funds to pay for their rent. There's going to have to be a lot of work done by attorneys to try to delay the eviction time, to try to keep their eviction off their record, to try to bring habitability claims that might reduce the amount of rent that they owe, all of which is very difficult to do without the right to counsel. Next slide. So housing is not the only area, as we talked about before, where we're seeing a spike. In some cases, parents that are essential workers who have been separated from their kids because they've been working while the other parent hasn't, and the parent who's not an essential worker in some cases has tried to keep the essential worker parent away from the kids on the grounds that it endangers them. Social distancing has also made visitation really difficult and other things. So the legal issues coming up around foster kids, around custody are becoming significant. This particular article was talking about kids in foster care and the birth parents losing access to visit them because of COVID-19 and how that could actually hurt their long-term chances of getting their kids back. Next slide. And then the unemployment is unsurprising. There are literally tens of millions of people have filed for unemployment. In a lot of the states prior to COVID-19, the states had made it much harder to apply for unemployment. So now we're facing lots of people who have been incorrectly denied and are going to have to appeal, and they're going to need counsel in order to do that. Next slide. As we talked about, the system wasn't close to meeting the demand before. We saw the statistics on how many cases involve at least one unrepresented party, the extent of unmet needs for the poor. And now, next slide, please, it's even worse, as you can imagine. The system is going to simply be overwhelmed absent something changing, and especially really difficult that there's an alignment between where COVID-19 is spiking and the places where representation is at the lowest. That's a devastating combination. Next slide. The last slide was interesting to me. It said COVID-19 may overwhelm our legal system. This one says COVID-19 will overwhelm our legal system, and this slide, I believe, is the right, takes the right position on the issue. Next slide. Where we're really hurting right now is especially because, as I discussed before, if there's a right to counsel where there is, some states, the states all provide a right to very limited areas, they cannot cut that funding. If they have a reduction in revenue, they're going to have to figure out, because it's a guaranteed right, how to fund those things. But what's provided for legal services, not by right, next slide, please, you're going to see exactly why we're going to be in such pain right now. IOLTA, which is one of the biggest funding sources for legal services programs, relies on the interest rates, which were just cut to zero. In 2008, when the financial crisis hit, IOLTA revenue dropped tremendously, and we're expecting another huge drop in IOLTA revenue, next slide please, coming because of the interest rates. And then in addition to IOLTA, a lot of legal services programs rely on court filing fees. They get a portion of the filing fees of all civil filings. And because no filings are happening in so many jurisdictions, the courts have halted that. That revenue is drying up at the same time also. And this one, program was talking about how they could lose half their filing fee income potentially during COVID-19. Next slide. So what are we doing to try to address this? Next slide. Well, we are still working to get the information out that people need to see about exactly why we need to do this, and especially at a time right now when the states are bleeding revenue. Understanding how much a right to counsel can save is going to be more important than ever. This report was just released for Baltimore, showing that a $5.7 million investment to provide a right to counsel for tenants, low-income tenants, would save the city and the state a combined $35.6 million. And it shows the breakdown of where that comes from. It's a combination of foster care, Medicaid spending, shelter, and other things. Right after the report came out, the Baltimore Sun editorialized and said that this is something the city should be doing. So we're still pushing for this. We're not giving up one iota of the gains that we made prior to COVID-19. And this report should help a lot in Baltimore to advance the issue. Next slide. This report in Baltimore also, the cost-benefit report also looked at the impact of providing counsel and found that 92% of those, if counsel were provided, that 92% of the tenants with representation would avoid disruptive displacement, and that right now about 80% of the renters that go to court unrepresented have a legal defense that they could raise, but only about 8% actually raise it. So that's part of the reason why we need a right to counsel, because so many people have a defense. And that about 90%, right now, about 96% of the landlords that head to housing court have representation, but only 1% of the tenants do. Next slide. the other thing that we're really doing is, as the advocacy continues about what reforms need to happen in housing court and what relief needs to be directed to tenants, we're making the argument that you need a combination of, you need rent relief or rent cancellation, you need eviction delays, and you need a right to counsel. All of those things need to happen together, not any one of them by themselves, and ensuring that that message is carried as it was in the CNN piece, fortunately, making it clear that the tenants need all of these things together is an extremely important message. Next slide. This is one of the main policy statements that was made by two major national policy entities, PolicyLink and Homes for All. They came together to create a COVID-19 policy about what to do right now, and they included right to counsel. It's actually off the slide. Unfortunately, you can't see. It's at the bottom that it says that for tenant protections, that right to counsel needs to be one of those protections that is provided to tenants in addition to rent cancellation and other relief. Next slide. Another thing we're really doing is digging into what's actually happening right now with the courts that are starting to proceed, to just paint a picture of how bleak it is and why doing this without counsel makes no sense. For places that are starting to do remote hearings, highlighting the access issues, people not having the right technology, they don't have broadband, all the technical difficulties that have come up on the actual calls where people are dropped or there's other problems hearing them, lack of interpreters, confusion about whether people are supposed to participate by phone, how people with disabilities are going to access it, how the courts are going to hold in-person hearings when immunocompromised people cannot show up, especially in high-volume proceedings where there are going to be a lot of people there, like evictions. Some courts are actually defaulting people that don't show up without a mask, believe it or not. Some courts are suggesting mediation as a solution, but we've seen that mediation without counsel is not very effective. We saw that in the foreclosure context. And then the illegal evictions we talked about before. So like highlighting all of this as the courts consider whether they're going to lift the moratorium and how they're going to proceed. That's a big piece of what we're doing right now to try to pull all that together. Next slide, please. We're also doing legal research to support keeping the moratorium in place and canceling rent, because the best way we can serve the right to counsel movement is to not have so many people that need counsel. So we've been doing research. We've done research actually in support of federal law around eviction moratoria and rent cancellation attempted at the city, state, and federal level, as well as by the courts themselves, tracking the jurisdictions that require CARES Act affidavits and supporting the research on people who are trying to sue the courts to keep the courts closed right now. So like basically, although not directly about right to counsel, it basically supports making the right to counsel demands more manageable. Next slide. And then advocacy around using federal stimulus dollars for legal rep. We talked about how there was the LSC funds, the $50 million, but there was a lot of CDBG money that was allocated to the states. We have it from our gurus at HUD that legal services is an allowable use of CDBG. It was before COVID. It is during COVID. We have heard of a few jurisdictions that are now moving in the direction of using CDBG funds for legal representation, as well as the Coronavirus Relief Fund, which is another pot of money from the CARES Act. I think I heard the first jurisdiction maybe using some CRF funds for legal reps. So we're trying to encourage people to think not just about direct rent relief, but also tenant representation. Next slide. We are still continuing our litigation. We're still having new cases pop up. Cases that we were working on before are new cases that were coming up that we're dealing with. The Hawaii and Indiana cases are brand new. They're the result of two decisions from courts of appeal that were very wrong that we're helping to file appeals on. We're still litigating the right to counsel on adoptions in Ohio. In other words, all the litigation work is going to continue. It's actually much less affected by COVID-19 than the legislative work is. And then we're going to, in some of the challenges to due process, whether the opened eviction proceedings provide due process, potentially arguing that they can't without providing a right to counsel. Next slide. And also because quarantine is a hot issue, and it's going to be an especially hot issue now that the states are starting to do contact tracing as they lift their stay-at-home orders and start to focus more on the individual people that are known to be sick. We did 50-state research on the right to counsel in quarantine, which is an incredibly complicated area of law. This map shows you what the law looks like, and you can drill down and see what Maryland looks like. And it's so we now have that research. So if people have questions about challenging the quarantine order, quarantine or isolation, either they've been ordered to stay home because they're sick, or they've been ordered to stay home because they were exposed to someone who's sick, which could potentially interfere with their livelihood or other things, and they need to challenge that. Potentially, we have the law on the right to counsel. Next slide. And we're still supporting I mentioned there's a lot of interest in Congress before. Just 2 weeks ago, Representative Kennedy in Massachusetts introduced a broad resolution in the House saying that that Congress needs to support the right to counsel in civil cases and get funding to the states. This will help in the advocacy around the stimulus package. It had bipartisan support, a good list of co-sponsors. We had a hand in the language that is in the resolution. Next slide. So some additional resources that are available to you as you if you want to learn more. Next slide. This is what you saw another view of our map before. This is the previous one I showed you if you want to know the right to counsel status, like for a certain subject area, whether the state has a right to counsel or not. This view is to see if you want to know what's going on by subject area. You can pick housing, you could pick child custody, you could pick domestic violence, whatever. You can even filter by, additionally filter by, I only want to know about legislation or litigation or pilots or whatever else, and then you can click on a state and get a pop-up that will tell you more information about that specific initiative. Next slide. This is our comprehensive bibliography. I mentioned that we have all the information about the studies and reports done about the impact of counsel and cost benefit. That's all in this bibliography. Sorted by subject area. If you go to a subject area and then choose the studies and reports area, you'll see what we have we'll have all the studies we know about with hyperlinks to where you can find them and read them. Next slide. Another really critical resource, this directory, which we worked collaboratively with the ABA to produce, instructs trial judges on when they must, can, and cannot appoint counsel for every kind of civil case that exists. There's an entry for every state, including Maryland. Next slide. This is what the table of contents looks like. It's extremely detailed. Next slide. And it provides, for every subject area, it tells them whether there's a statutory right to counsel, a constitutional one, a court rule, whatever it is, in great detail. It instructs the judges on what they have to do or can do, what they have the discretion to do. Next slide. I cannot also emphasize enough, the National Housing Law Project has tremendous resources on their website if you're looking for eviction resources. They have a really great document on due process concerns about these reopened hearings. They have pleadings for some of the litigation challenging some of the reopened hearings. They've got analysis of the CARES Act and what it covers, and just a tremendous wealth of resources. So I encourage you to go there. Next slide. The Eviction Lab also, in collaboration with a Columbia professor named Emily Benfer, has a very comprehensive analysis of what the eviction moratorium in each state cover. You can see here, this is Massachusetts. It shows you which stages of the eviction are stopped or what other rental protections are provided. You can see that legal counsel for tenants is one of the things that it measures. That was our contribution to this piece. There's also another one done by ProPublica where you can actually specify an address, and I should have had that in here as well, but there's a ProPublica tool, you can Google it, where you can put in an address and it will tell you what eviction moratorium protections apply to that address. Neither the ProPublica tool nor this Eviction Lab tool currently cover city-level moratoria, but the ProPublica one is planned to in the future. Next slide. Another really important, if you want to stay informed, we have a way to, we have e-alerts that we send out a couple times a month. You can sign up for those, and of course check out the latest news on our website. Next slide. And this is my contact information. I'm happy to answer questions if people have questions after this presentation and we can't get to them. This was a lot of information done in an extraordinarily short amount of time, and I realize that, and I'm talking very fast, and I appreciate your patience with all of this. Just, in closing, I would just say we really don't know where things are going right now with the movement. We were really on a roll before COVID-19 hit. In some ways, that should not change because the demand and the outcry for it is greater than ever. We recognize that with the funding cuts that everyone is facing, that it's going to be a real challenge to keep pushing forward. But we have hundreds and hundreds of people across the country. They're committed to Right to Counsel, to making it part of the messaging, to ensure it's included in the relief, and to continue the initiatives that were started before COVID-19 hit on housing, on domestic violence, on all the areas that the work is being done on. And we know that the issue is not going to go away. It's too much in the forefront now. It's too understood, too well known for it to go away completely as an issue. So I'm going to close there, and at this point I will open it up for any questions that people have.
Okay, John, thank you very much. One of the things was, please make these slides available. They are excellent. Just a comment, not really a question, but everything will be up on the SharePoint webinar page, you guys, so you can find it there. Molly Bodendorfer has a question. Can you tell us the actual case name of the Maryland guardianship case?
Yes, it is called, and actually I'm hesitating only because I want to make sure that the names are not redacted. It is In Re Joyce. The decision which was issued, it's an unreported decision. It was issued on May 4th. The site is 2020 Maryland App Lexus 43. That's the decision that sent it back down to the trial court. It's a very complicated case, but there's a question about whether the trial court actually, she had a volunteer counsel that tried to get themselves appointed. The trial court didn't even allow that to happen, and on the record, but then sort of accepted some of things that counsel had filed. So the Court of Special Appeals said, we're not really sure if the trial court did accept that appointment or not. But even if the trial court did accept that appointment, when they move for appointed counsel fees, which they would be entitled to if she has a right to counsel, the issue is going to come back again. So we know that the case is far from done, even if it turns out the trial court allows her retained counsel to appear. The guardian for this person took the position that she didn't have the right to hire counsel. In fact, they took the position that she didn't have the right to either hire counsel or challenge the guardianship at one point at all without the guardian's consent, which is kind of a little bit of a circular thing. The guardian argued that she couldn't seek the medical records that were necessary to challenge the guardianship without the guardian's approval, which is kind of creates a catch-22. But I'll let you all read that. You can read some of the facts from the unpublished opinion.
Okay, great. And then Molly also questioned, are you all doing any work to rescind Judge Barbera's order that on June 12th, any rent escrow accounts not fully paid case will be summarily dismissed?
That's not something I was actually aware of. I suspect that my colleagues at the Public Justice Center, who are more focused on the goings-on in Baltimore and Maryland than I am, would be more attuned to that, but I can certainly raise that with them. I was not personally aware of that.
Okay, good. All right, well, that's all the questions that we have. And I want to thank everybody for being here, and I hope that you got a lot out of it. I did. And we will take care and have a great weekend. Thanks again, John.
You're welcome, and I will get you, I'm going to make a tweak to a few of the slides, and I'll send you an updated deck right afterwards so you can post the updated deck. If that's all right with you?
Yeah, that's perfect. Thank you.
All right. Thank you, everyone.
Thanks for coming.